Welcome to the HealthLaw HotSpot. HealthLaw HotSpot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the HealthLaw Hotspot. I'm Ericka Adler, shareholder and leader of the healthcare practice at Retzel and Andrus. Today, we are revisiting our top topic from 2024, which has to do with protecting your practice brand. Today, we're going to be talking about some tips, tricks, and strategies to do just that. And my guest is David Adler, president and founder of the Adler Law Group. He's an intellectual property, corporate, and entertainment lawyer. And he's going to talk to us today about some things you need to think about if you're trying to make your practice stand out and protect it. So, David, welcome. Thanks for being here.
Yeah. Hi, Ericka. Thank you for having me.
So,
It's very exciting to talk about this. I was very interested to see that we were this was the top topic for last year's podcast. And, I know why. Marketing is the cornerstone of every medical practice, right? And these days, there's so many different opportunities and ways to market your practice. There's online marketing in the form of social media. There is email marketing. And of course, there's always traditional print and television and radio advertising. But across all of these different types of communication, the most important thing is to have a strong brand that resonates with your customers so that when they have an issue, they think of you.
All right, that makes a lot of sense. So let's start at kind of the beginning of that branding process. A practice decides to form a new entity, okay? Or they get down and they think about, maybe we should pick up a DBA or a name to kind of better market ourselves. A lot of practices use very regional sounding names, right? So Midwest this, Lakeshore that, North Shore this, whatever. Nothing wrong with those names, particularly when you're servicing a particular community. But how does a name like that really protect a practice? Or are there going to be issues with choosing a name like that?
I think that's an excellent question. Actually, I think you've got three different questions there, right? Like the first question is, what makes a strong brand? And when you're thinking about what you want to call your business or what you want to call your practice, that's the first thing you think of. What's a good, strong name? I think the second thing that you talked about is, how do you protect that? And we'll kind of get to that. But I think it's important for people to understand what makes a brand a strong brand, right? And you mentioned that it's very common for a practice to name themselves something, that's regional, that's geographic, that sort of may resonate with their consumers, right? Like the, North Shore, whatever practice, or, the Greater Chicago, this, that, and the other thing. And those are good, but, in order to have a strong brand, it needs to be a word or a phrase that's memorable, right? And so if we think about brands kind of running on a spectrum, at one end we have words that are sort of generic or descriptive, and at the other end we have words that are made up, arbitrary or fanciful, right? And so what do those look like? So a generic word might be like coffee for coffee, right? You can't brand your coffee. You could brand it anything else. A descriptive word would be something like Midwest or North Shore or, best or, top notch or number one, right? So things that sort of describe an aspect of something. Arbitrary and fanciful marks are really made up words, things like Google, Xerox, Kleenex, although I know they've come to be used more like common everyday words. But those were originally, totally made up words when they first started using them. So the more distinctive a word is, or the more distinctive a phrase is, the more protectable it's going to be. So when you're thinking about branding your business, when you're thinking about creating that name, you need to really think long and hard about what can I do to make my name stand out from the rest, right? Yes, it's important that your clients or, your customers recognize some part of what you do, right? When you say you're, the North Shore specialist in da da da, right? People on the North Shore are gonna be like, okay, yeah, that must be close to me. That's relevant to me, right? But the problem is there's nothing inherently distinctive about that. So other businesses might be able to use the same kind of phrase or the same kind of descriptor for their business, right? And so then it's harder to distinguish you from your competitors, right? So that's why we're talking about using words that are fanciful or arbitrary. To give an example of an arbitrary name, the word Java, which we all think of kind of means coffee, is actually a word that's applied to computer software that was created by Oracle. So, the Java trademark, although you think of coffee, is really something for software. So that's an arbitrary association, which is why it's more protectable.
Okay, so that makes sense. So so maybe a combination of a name that allows people to know where you are and what you do with some kind of twist on it that makes it somewhat unique. So let's just say, North Shore Dental Practice, North Shore Medical Specialist, Chicago Dentistry, we see a lot of those. So if you are forming an entity with a name like that, what's to stop you from using that name? I assume one of the first things you're going to do is you're going to talk to your lawyer. Your lawyer's going to go on the website and say, okay, that name's available. All right. Now, if that name could be available simply because somebody has an LLC by that name instead of a corporation by that name, or they have a hyphen, or they have an S where you don't have an S. So you can have a name that's almost identical to your own name being taken by someone else, or you could be choosing a name that's almost identical to someone else and maybe not even realize it. So first you should be looking for, somewhat different combination on the state page. You see the name is available. I think a lot of people stop there, right? But I know that there are other things they should be doing. What do you recommend before they just assume that because a name is showing up as available, that they should take it? And putting distinctiveness aside, which we'll talk about a little bit more, but their first step usually for most of my clients is going to be, is it available on the state website, right? What else, though, should they be thinking about?
Yeah, that's an excellent question. So once you've kind of figured out what you want your name to be, you need to sort of engage in what I call the pre-flight checklist, right? Or doing some kind of a knockout search to see if the name that you've chosen is actually available. And there's a lot of different resources to check, right? So you mentioned checking the state database. Illinois, like many states, has an online database where you can check not only the name of a business, but also if that state has any registered trademarks. So that's the first place you want to start. You want to look in your state database. You want to see if any other businesses are registered using the same name or a similar name. And maybe we should kind of back up one step and say, what are we trying to avoid, right? What's sort of the touchstone inquiry that we need to make before we kind of protect or go after a particular brand name, right? And that is, it has to be something that is not likely to cause consumer confusion, right? So consumer confusion is the touchstone. We want to avoid things that are going to be confusing to consumers. Well, what does that mean? Well, it doesn't mean it has to be identical. It just needs to be substantially similar. And we're not going to go into the sort of the legal details of how you measure all that. But, suffice it to say, if it kind of looks like a duck and it quacks like a duck, then maybe it is a duck, right? So the more things look and sound alike, the more you want to stay away from them, right? You want to make sure that your mark doesn't look and doesn't sound like anybody else. So how do you find that out, right? So we just talked about searching the state trademark data, or I'm sorry, the state database. Is there anybody with a registered trademark in my state? Or is there anybody using a business name that's similar to mine? Now, one of the problems with corporation and LLC and partnership names is the state doesn't really make a big distinction, and they might allow different names that are highly, highly similar to be registered as the name of a business entity. That's not quite the same thing as a trademark, although it does implicate trademark rights. So while it's always a very good first step to look at that state database, that's not where where the search ends. Okay. What any seasoned trademark lawyer will tell you is that you have to look at the federal database as well. So the United States Patent and Trademark Office maintains a very complex and very searchable database. You can search words, phrases. You can search images, so logos and things of that nature. And you can check and see if anybody is using your particular trademark, your slogan, your name, for any goods and services that are similar to what you're doing. So if you're in a medical professional, you might search things like, your specialty: podiatry, dentistry, aesthetics, surgery. You might do a broader search for medical services in general, right? So that's kind of the key to making sure that you can move forward with your branding. Once you've cleared uh, those searches, you checked your state databases, you checked your federal database to make sure that nobody else is using anything confusingly similar, then you can move forward with your brand. Now, there are nuances to this, right? It's not always black and white. Sometimes you do a search and you find the exact same word, and then you can say to yourself, okay, here's somebody using my exact same name for the exact same thing. They've already got it. I'll move on. But sometimes you find words or phrases that have some words in common, but maybe not all words in common. So it really helps to, use somebody who's familiar with trademarks to kind of evaluate both the strength and the weakness of that mark and your mark. And, is there some gray area in the marketplace? Are the goods and services related? Maybe this trademark has been registered by somebody who's in a totally different industry than you are, and there wouldn't be a likelihood of consumer confusion. So it's a process, and it's definitely, I think, the most important thing to do after coming up with that new name for your business.
Okay. So most, doctors that I work with are probably going to look on the state page. They might Google, right? But very few are actually going to the trademark search process. They think of the names are very generic. And just by looking at the dentists and medical practice names in the area, most people are just kind of choosing something very simple, and they're assuming it's going to be safe. One of the issues I see as a healthcare lawyer is if you have a name that looks very similar, we get into issues with liability. So if somebody's looking to sue a doctor they saw at this practice and your practice sounds similar, you might get yourself kind of tied into that. Of course, you can get yourself taken out once everybody proves that it wasn't you, et cetera. But it's just a good example of some of the confusion, right? Or, it's visiting patients who visit practices with similar names, and we get into billing confusion. So it does happen regularly. But one of the things I want to mention is that, do we really need to worry if somebody's showing up on a trademark with a similar name, but it's in a different state, right? So there's the state trademark database, you check that out, but then you look on the federal trademark and, well, there's somebody with an identical name, but, they're in California or Michigan, and you're sitting here in Illinois. Well, does that really matter? Because they're not here in Illinois. And what would you usually say about that?
Well, to most of my clients, I would say it sort of depends, but the better practice is to protect your trademark, right? So if you see somebody using a similar name for the same kind of business in another state, you need to ask yourself, have they been using it longer than I have? Or have they adopted it after I started using mine? And that's an important distinction, because in trademark law, first in time is first in right, number one. So the first person to start using a trademark is the senior user. They have the more protectable interest. However, trademark law does recognize that there are differences in geography, and some types of businesses are maybe just local businesses. They don't necessarily cross into other states. And so I think that's something that you have to evaluate as a business. Now, with all that said, the one thing I will tell you is that the way businesses advertise today inherently crosses state boundaries. It's international, if not at least national, right? So, in thinking about how businesses advertise themselves, using social media, using email, having a web presence that's searchable by Google, having a listing in these other kind of directories, those those are going to bleed into other states, right? And people from other states are going to see you, they're going to see your competitor. And so that starts to present, a trademark risk to your business, not just the confusion with regard to maybe billing, or confusion as to, who's the proper defendant in a lawsuit, but, more importantly, it could erode your brand, it could weaken your brand, it could lead to consumer confusion, right? And that's the whole thing that, trademarks are designed to protect against.
Right. All right. So a couple things. First is that if there ends up being consumer confusion and you're not the ones with the greater rights, then it can be quite expensive to have to rebrand, right? So obviously getting it right from the start could save you money in the long run, even if you're
100%.
to have someone look at it. But some of my clients, and you'll know this well because you've worked with some of them, may receive a letter telling them that, in fact, they are infringing on somebody else's rights by the name that they're using. And, some of my clients may be listening to this and recognize this, this fact pattern. So if somebody does receive a letter that alleges this, what are your thoughts on that? And what are the recommendations?
Well, you always need to take these kind of letters seriously, number one. Number two, you need to act promptly because sometimes, when you're talking about trademark rights and you're talking about the potential for litigation, time can definitely be a factor. The amount of time to investigate, the amount of time to respond, especially if there are, if a lawsuit is actually filed or is about to be filed. So you need to be able to get your ducks in a row. You need to evaluate the strength of the claim, right? I have seen cease and desist letters for names for which there is no real recognized protection. Either the name itself is a sort of a generic or descriptive name, or maybe the person who's using the name hasn't taken the time to register it as a state trademark, or more importantly, as a federal trademark. So it's very important to understand the strength of the party asserting the claim. Now, if the letter says, here's our trademark, U.S. federal registration number, da 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 da, again, it's important to know because here is federal, here is legal proof that they own this trademark, and depending on how similar your trademark is, there may be an issue. So, once you've done that, the other thing you need to do is say, okay, are the businesses related? Are the goods and services related? Do they travel in the same channels of trade? Is there really a likelihood of consumer confusion? Or is this some tire manufacturer from Ohio simply using the same name that I'm using for my derm practice in Chicago, right? So if the businesses are totally unrelated, there's again a less likelihood of confusion. And, you know, it certainly weighs against the claim of the party who's asserting the trademark. So again, everything needs to be weighed in context. You can't just look at one factor in isolation and kind of decide your response to that. But once you've done that process and you got a sense of how serious this claim is and how soon you need to respond, again, talk to your lawyer, prepare a proper response. Sometimes a proper response is to say, hey, you know what, I don't think you're right. Here's why, have a nice day. Sometimes the response is, okay, I see where you're coming from. Let's talk about a resolution. And, it could take a lot of different forms because, again, trademark rights are weighed against each other. No, there's never any absolutes.
Right. And I guess part of the problem is that these days, a lot of practices with telemedicine, et cetera, they do have plans to be national. So they may not be in your state, but they may be planning to come there. What happens if somebody does register a federal trademark, but then they send you a letter, but you've been using the same name for 25 years and they just registered their trademark last year, but they do have a federal trademark? How might that be different than the fact scenario otherwise?
Right. So let's kind of talk about what is a federal trademark and kind of what rights does that confer. Trademark rights arise from use. So there's no requirement that you actually register your trademark to have rights in that. And that means the right to prevent others from using a name that's confusingly similar. Now, those rights have limits, okay? They kind of end at the state line, and they are limited by what you can prove in terms of how strong your mark is. There's state registered trademarks that kind of give you additional notice as well as some additional statutory protections within the state. And then there's federal trademarks. And when you register a federal trademark, it gives you the legal presumption that you are the exclusive user of that trademark throughout the United States, number one. Okay, so that's a really big legal presumption. That means when you go to court, it is on the defendant to prove that they are not violating somebody else's rights. Okay, so the burden shifts. That's very important. The other thing is, for a federally registered trademark, there's additional enforcement, and a junior user's trademark does not need to be identical to be enjoined or to be stopped. If it is, if it is similar and it's, close enough that a court would find that there's a possibility of confusion there, the junior user can be stopped. Now, to your specific fact pattern, the junior user is actually the party with the registration, and the senior user is the party who started using the trademark first. And like I said, one of the foundational principles in trademark law is that first in time is first in right. So the business that started using the trademark first certainly can't be stopped, right? So the junior user, even with their federal trademark, can't stop the senior user from using their trademark. However, the senior user's sort of scope of use is kind of limited to what they can prove that they have advertised or served. So if they're a small community practice and they've never really serviced anybody outside of the little town that they're located in, it'd be very hard for them to assert any sort of national rights or even any statewide rights. And, it'd be very likely that the junior user, the party with the registration, would be able to sort of take up any rights in those areas that the senior user isn't using it. Now, again, if the senior user can establish a broader scope of rights, maybe they're in the adjoining state, okay, or they're in in another state elsewhere in the union, they then have protection over those areas. So the junior user in that case would not be able to stop them, but certainly would be able to prevent them from expanding.
So basically, they would reach some type of agreement that says, I can keep using my name, but I can only use it in my town or in my state or whatever. I can't use it elsewhere. But you, having the perhaps almost identical name to me, can use it elsewhere. And that's kind of interesting because, of course, people are never sure, who's who after that point. So could it help, the smaller practice because suddenly their name is becoming well known? Yes, but it's not them, right? So it's kind of an interesting situation. But certainly it happens, and you and I have kind of been through that with practice as well. So I think it's a really interesting situation.
Yeah, it does. And, we were talking earlier about the importance of doing a trademark knockout search, right? So the trademark knockout search finds these little businesses that have been existing out there without state trademark registrations, without federal trademark registrations, but maybe they've been using their name for 5 years, 10 years, 15 years. And so there are some protectable rights there.
Okay, well, let's talk about like when the names are, fairly generic, but they're associated with, let's say, a unique, um, a symbol or a logo. Because a lot of my practices that I work with have really beautiful logos that they use. Now, they need to consider protecting that. And is that, is that a separate protection? So might they have better rights in the logo versus the name, or are those going to automatically be tied together? How does that work?
Right. That's another excellent question. So trademarks kind of come in three flavors. You've got a word mark, which would be a phrase like Coca-Cola. You've got a logo, which would be like the target circles, right? There's no words, it's just the circles. And then you have a combination of the two, which would be both a logo and a word, right? And so you might think of the Coca-Cola script. There are many other restaurant logos out there where there's both words as well as a design element. So it really depends on how the application is filed. If you have a logo and you have some very, very generic words, but you want to be able to protect those words, then one possibility might be seeking registration of the logo with the words, as part of the overall mark. Okay. That would not necessarily give you exclusive rights in those words, but it would at least give you some basis for protecting them if they were otherwise just generic or too descriptive. Because the graphic element itself gives the trademark somewhat of a distinctive appearance, right? And we talked about protectable marks or distinctive marks. So how can we make our trademarks distinctive? Having a logo definitely makes it distinctive. And, as creative as you want to be, there's all kinds of different ways to depict letters and numbers in creative ways that kind of also add that level of distinctiveness. But you can protect the words, you can protect just the logo, or you can protect the combination of the words and the logo.
Okay, perfect. So, practices who are thinking, how can I make myself more distinctive? Maybe adding color or logo or the script, whatever might be the way to do that. All right.
Yes, kind of some sort of stylization, right? Even if you just took a regular word and you decided to maybe depict it with more fanciful lettering, okay, or just different font style, or some kind of graphic element so that at least it looks different.
What do you recommend in terms of practices? Let's say, practices have kind of like a distinct words. Like I have a lot of dentists that I work with, and they might have a word in their name like smile or, um, you know, teeth. Obviously, that's a little bit more common, but where they've come upon a certain word that they're basing their name upon, maybe even multiple locations, and they know somebody else is thinking of using that identical name. Is it a good idea for them to somehow be tracking, maybe looking up their name regularly, or once they've got their name because they're the first in time, they don't really need to worry about it. How much, monitoring, I guess is the right word, should practices really be doing?
I think that's an excellent question because I think a lot of trademark owners don't realize that they actually have an affirmative obligation to police their trademarks. So you really need to have some sort of method of going out there and at least searching occasionally, whether it's once a month, once a quarter. Uh, is there anybody else who's adopted a similar name? There's a couple of risks associated with that. If somebody else does adopt a similar name and you ignore it, that weakens your name and it becomes harder for you to enforce your name down the road. At the same time, once you discover somebody is using, has recently adopted a new name, that's really the best time to take action because, it's going to be less expensive at that point in time for them to rebrand, should that be the outcome that, you are looking for, right? So, it's important to kind of stay on top of that stuff. There's a lot of different tools that you can use. Google has a free alerts system, which is a great way to set up a scheduled email to just run a Google search on a particular phrase, right? And it's going to turn up probably more information than you need, and the results are not going to be super accurate, but if nothing else, it's a great way to monitor that stuff. But yeah, I mean, you should absolutely be checking that on some sort of regular basis.
Right. I think it's a great idea. And, there are so many practices. People are using, social media, and people are getting their name out there. So it's not like you're just have your practice and you're just going about your business. There are just so many practices with so many similar names now that even if you try to be unique, other people see you're doing that. It's easy for them to find you on the web and to copy your ideas. So I really feel like, practices that feel they're being super cutting edge with their logos or their names really need to, after they put the time, the money, and the effort into choosing, that name and their branding, to really spend the time and effort to protect it, or else, they've really wasted, that time and money that they've put into it. So I like to see my clients that are doing that. For some of the practices that have been around a long time, their names are well known. Perhaps they don't have the same concerns because they're so well known and so established. But certainly for newer, younger practices, it seems such an important step to take. Um,
Yeah, it's a really important point that you make. So even if a business, for those businesses that have been around for 5 years or more, they can actually seek registration based on what's known as acquired distinctiveness. So even if they do have one of those trademarks that's kind of on the more descriptive end of the spectrum, like North Shore foot surgeons, and my apologies if there is one, but something like that that's highly descriptive of the business. If they've been around for more than 5 years and they can show that they've been doing advertising and they've been successful, I mean, there's a lot of different things that you can use, but you can prove what's known as acquired distinctiveness. And trademark law recognizes that even though it is a descriptive phrase or descriptive name, over time, it can become protectable because it has a secondary meaning in the minds of consumers. So that's an option as well.
that's great to know. All right, so we've talked about a lot here. We could probably keep talking forever, but I want to kind of wrap this up. Are there any particular additional tips or tricks that you want people to know about that we haven't covered, or any kind of final, last words that you want to share?
Yeah, I think we covered a lot of stuff. The advice that I give to my clients is it's never too early to start, thinking about how do you protect your intellectual property. It doesn't hurt to sort of cast a wide net and think about, okay, what am I using today? What am I using in the future? What do I need to do to protect my trademarks, to protect my names, and really set myself up for success in the long run? It's much better to spend the money now and invest in protecting this stuff than to try and have to backfill it later, or find yourself scrambling to shore up your IP protections when you're staring down the barrel of a lawsuit, either as a plaintiff or a defendant, right? It's just these are things that can be done ahead of time, and they're very good. They're very sound business practices. They add value to the business. They are considered independent assets of the business, so really there's no downside in doing it.
All right, perfect. Well, thanks for all that advice. And this has been David Adler from the Adler Law Group. We'll share your information when we post this. If you have any questions, please feel free to reach out to me or to David directly. And this has been the HealthLaw Hotspot. I hope you'll join us next time. And you can always reach me at eadler@ralaw.com if you have any questions or comments. See you next time.
The Retzel HealthLaw Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel HealthLaw Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel HealthLaw Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.